All right, welcome everybody. If you are just arriving, walk to the front, find a chair, don't just look for the aisle seats. And I want to make sure everybody can hear us. So one of you that knows what we do, raise your hand or something if you can hear the sound of my voice. I'm not seeing a bunch of hands going up yet, but I think somebody can hear me. Ah, there we go. I had to scroll down. Wonderful. All right. Well, welcome everybody. I'm going to start off by introducing my favorite title rep, Lynn Dang. You might think that all title companies are similar and all title reps are the same, but that ain't so. And the amount of service that you get varies a lot, which is why I work with Lynn, because it's hard to find anybody more helpful, more knowledgeable in the escrow and title business than Lynn. And so I'm going to let her take over and let everyone know why we're here and what we're doing.
Thank you, Mike. Thank you for having us. Good afternoon, everyone. For those of you that don't know me, my name is Lynn Deng. I am an account executive for Chicago Title in Santa Clara Valley. And just a little bit about myself. I've been in the business for 7 years. I started out as a real estate appraiser, and I'm still licensed. I just cannot do any appraisals because it's conflict of interest with Chicago Title. I have done 10 years in lending. So I bring with me, I've touched all facets of real estate, so a lot of knowledge to share with you, have great work ethics. So my main job is to provide resources, tools, and share my knowledge. And my number one goal is to help you grow your business. So would love to have the opportunity to meet with you one-on-one. One of these days, feel free to reach out to me. I'm sure Mike is going to leave my contact information at the end of the presentation. But today, I brought with me Melissa McRoberts, who is the escrow officer. She's one of my best escrow officers. She's been in the business for over 20 years. Yes, she started when she was 5, but have a lot of knowledge, have done all real estate transactions except for mobile homes. So you can talk to her and ask her questions about anything related to title and escrow. But today's topic, we are talking about escrow and title red flags. And with that, she is going to share her real life experiences with some of the stories that she had dealt with, some of the transactions she have dealt with, and shed some light into what kind of issues that we came across with, and feel free to ask questions. So take it away, Melissa.
Hi, everybody. It's a pleasure to be here and to be chatting with you. I was telling Mike earlier today, it's a really good time to be doing this class. When the market slows down a little bit, we get a lot of interesting kind of files. People are trying to put together deals, and we get a lot of title reports that have some different things that we don't always see all the time. So I've got a few examples for you. I'm going to go ahead and share the flyer, and you can read along with me or just listen to me talk. And of course, any questions, put them in the chat box. If I don't catch them, Mike will catch them, and make sure to ask questions, because that's what we're here to do. Lunch and learn. All right, let me get over to my flyer. And bring this over. All right, so I've got it up. First things first, it's always property taxes. Property taxes we got to watch out for. A lot of people don't know that if you are in property tax default with the county can actually default on the property, and somebody can actually auction to purchase the property. It's a very sticky situation in the sense that it takes a long time for a person to take ownership of. So we always want to make sure that we have our property taxes. Another big thing about taxes that are going around right now is there's a program called HERO, and it's a program where individuals can borrow money to fix up their home, make it more energy efficient, and they can get these loans through the county, and the loan gets attached to your property tax bill. So if your property taxes were, say, $3,500 a year, you get a loan for $20,000. They're gonna, prorate that and divide that into how many years and add that to your tax bill. Well, we've got a lot of seniors as of late that are struggling to pay those loans and pay that increased property tax bill. And as a result, they're losing their homes. So again, you want to make sure if you've got seniors that have these HERO loans, talk them through it. If you do have a seller with a HERO loan, you need to know that we have to order a payoff demand, and that seller, in addition to whatever current mortgages they have, will need to pay that loan in full as well through escrow. CC&Rs are interesting. 99% of all properties have CC&Rs on their property. We like to, you can reference your CC&Rs to determine whether the property is a planned unit development rider, a PUD, or a CC&R, an HOA condo. That's always helpful. A new thing that's also coming out with CC&Rs is the counties in California are allowing individuals to go in and have certain things redacted that are derogatory or offensive. You remember, if you think about it, some of these CC&Rs were prepared and recorded back in the early 1900s, some as late as 1800s when the property was developed. So they can say some pretty odd things and have some derogatory information in there. So the county has now decided that if you personally take issue with things that are in the CC&Rs, you may go in and file a form. Of course, there's a fee to have that redacted or blacked out from the CC&Rs. Excuse me. Each county is doing it a little bit differently. We don't have a lot of information about what the fee is, but that is an option, and I wanted to put it out there because it is relatively new. Let's see, we have easements. Easements are pretty standard. They allow the city and county and PG&E and water to have access to the properties. There aren't a lot of red flags to watch out for, but it's something to contemplate and think about if your clients are looking to purchase a property and maybe they want to add a pool or they want to add an ADU. Then you need to think, they need to take into consideration where the easements are. One thing, I had a client call me the other day. So PG&E is now working on putting their lines underground. And as they're doing that with different neighborhoods, they're actually recording new easements onto the properties. So if you get approached, if your clients are getting approached by PG&E as they're doing this, they are asking individual homeowners to re-sign new easements to indicate that the lines will now be underground. We also have agreements for road maintenance agreements, shared driveways. I've had a couple escrows mostly in the Alameda area in the Oakland, where homes will share a driveway or share a walkway to the driveway, and there's been fence line issues that they've had to work out together. Some have even gone into mediation because they could not agree on different things. So at that point, you'd have to have your seller or your buyer get into mediation with different attorneys. That's mostly typically what I see is you know, either there are access roads in between properties or like an alleyway behind, you know, a
It
street.
happened often in rural area too, like Santa Cruz
Yeah.
Mountains and so on. Yeah,
Yeah.
there's
Yeah.
private roads.
And the trust deeds is, you know, it's a word, but we refer to them more as deeds of trust. Something that a lender or a person would go and record against the property if they have borrowed money or they're owed money against the property. Most of them are pretty common. We will obtain the information from the seller, who their current mortgage company is. We'll reach out to them directly and obtain the amount that's due to pay off the loan. I've had a lot lately of private lenders or hard money lenders. When we have hard money or private lenders, they are different from your institutional, your Bank of America, your Wells Fargo, in the sense that we have to work with them. The institutional lenders will automatically prepare and record a reconveyance, which removes the lien from the property. If it's a private lender or a hard money lender, then, you know, we will have to reach out, find out if we need to prepare the reconveyance and record that. I had a transaction. It was an elderly couple. I think they had actually passed away, and the children were selling the home. Well, they had borrowed money from some people probably close to 30 years ago. It wasn't quite 30 years because we couldn't remove it out of by time. So I had to track these people down. Of course, after almost 30 years, the loan was paid in full, and I think it was only maybe $30,000 at the time. But I had one that I was able to track down in Hayward. The other couple was actually in Arizona. And through Google and through my title officer, who's got some channels I'm not quite sure, she won't share with me, was able to find and found a phone number. But I had to track them down to get this reconveyance because, of course, we can't transfer ownership to a new individual, even if there is a $30,000 deed from almost 30 years ago. It's still going to cloud the title. It's still going to affect the new buyer unless we figure out a way to deal with it. So that's really what we find when we see different deeds of trust. And we want to make sure if you have a prelim, look at it. Look at the dates that they're recorded. If you see something that's recorded in early 90s, you know, late 80s, even prior to that, you're gonna know at that point that that's probably an old deed of trust and it needs to be dealt with. We should start talking with our seller right away to see if they've got any documentation. A lot of people are always, you know, pretty quick to say, oh no, I don't have anything. But the honest answer is we truly need their help. We need an account number. We need, you know, who that person was. A lot of mortgages get transferred over the years. And it's so important that we have their help and assistance, because we can spend days, you know, trying to track down this lender was sold to this lender and then transferred to this lender, and you know who ultimately had this loan when it was paid in full. It's really a difficult process at times. Then we have down here on page 2, encroachments. I don't really see a whole lot of encroachments, to tell you the truth, but then this, you know, again, comes into driveways, fences that may be in an easement line for PG&E. I've noticed, you know, and I've noticed that there's some ADUs, or they're very popular right now. People are doing them. If they're not particular about where these easements are, and they just put an ADU that's unpermitted, it could be a problem for them when they go to sell the house. It could be a problem for the future buyer. You know, there's a lot of people that are putting them on without being permitted, and that they could be forced to tear it down. prior to selling, or then the buyer would have to tear it down in order to move forward. It could affect the lender. If the lender sees that there's an encroachment on the preliminary title report, they may not move forward with the loan because of it. That's the kind of problem that it can be. It can be that problematic. So, you know, people need to be careful. And it's not even just ADUs. It could be like a permanent shed that's been built, things like that. Court orders and judgments. These are always my favorite. Court orders, anything that's by the court that has been recorded against the property or the person that owns the property specifically. Child support, alimony. Mike and I had a file a few years ago now that the seller owned, or the seller that owned the property, he had since been divorced. Their child was actually grown in their 30s, and there was a child support lien. And I contacted the county. The county didn't have any record of it. You know, we kept thinking, oh, this child's already 30 years old. It's got to be stale dated. You know, it's done and over with. So I finally look at the child support lien, and I get in contact with the attorney. And the attorney hadn't spoken to the ex-spouse in a while, but I finally got a hold of the ex-spouse, and she was very bitter and unhappy. And she said, no, I did not receive this money, and I intend to collect it. And, you know, here we are at the 11th hour, and now having to negotiate between these ex-spouses because she refused to release the lien. So, you know, those are things that happen, and they will affect your transaction. They can actually delay it. And, you know, even in that particular scenario, it still was ugly, because still, you know, we agreed to hold some money, and they couldn't come to an agreement. And, you know, I'm not even sure what happened after that, but I'm sure it wasn't healthy or happy story at the end. Bankruptcies. I have a transaction now that is, you know, the sellers had filed bankruptcy, and it has since been cleared. And it was interesting. It took me a while. I talked to some attorneys. I talked to title. On our prelim, there was a lis pendens. And a lis pendens is, you know, usually when somebody's trying to get money from our owner. But in talking to the attorney who filed it, they were indicating that there was a disagreement with a creditor, and the clients were going through bankruptcy, and they recorded a lis pendens on their own property to protect them and protect any homestead, or protect this from this creditor taking over and filing a mechanics lien on their property. So my owners now have to hire an attorney, because they have to release this lis pendens for that was, you know, from the bankruptcy after every, you know, now that it's been settled, and have this, it's called a withdrawal that releases the lis pendens. So they've got to hire an attorney to have this prepared so that we can move forward. Because again, like I said, if we don't handle it in escrow, if we don't take care of it prior to closing, it's going to follow the new owner. They're going to go to refinance, and this lis pendens or this child support lien or this old deed of trust from the previous owners, mind you, it's all covered under title insurance, but if it's not dealt with, it's going to follow the property everywhere it goes. We just talked about pending actions. Those are a big red flag. Again, these can be lis pendens. These can be other kinds of judgments, court order judgments that require us to reach out to the party or attorneys representing the parties that have filed these liens and get a demand to find out exactly how much is owed. Sometimes they have an amount on the recorded document, sometimes they don't. And sometimes they have an amount, but it's been outstanding for so long, the amount of fees that have been tacked onto it are astronomical. So we're can sometimes be very surprised at what we see when we get these demands back. In addition to the demand, as I was stating before, the attorney who filed it or the parties, the creditors that filed these liens need to prepare and provide escrow with a release or withdrawal. And that actually gets recorded against the, gets recorded at with our transaction and records with the county. And that's what actually removes these items from the property and from that particular individual. You'll see a statement of information, and if you're doing a listing and you know your seller has a common name, it has, a Nguyen, a Smith, it's always a good idea that we talk about that and get what's called a statement of information. Is called an SI for short. We can send it over to you. I can send it to the sellers via secure email. They can complete it via DocuSign. If we do that up front, then we can have them complete it. Title will run the information because chances are there's so many liens under an R Smith or a T Win or a V Fam. They can't possibly print them all or email them all to us and have us go through it, or even worse, send it to the client and have them go through each and every one of those liens. So with the statement of information, we're able to narrow it down from hundreds to, 1 to 10. And then from there, we can have our client look at it and say, okay, this is not me. This is not me. I've never lived at this address. I've never owned this business. What we're running for, we've changed it as of recent. We're looking for specifically tax liens, whether they're individual or business. We're looking for child support or spousal support liens. And yeah, I think that's about it. Those are the primary liens that we're looking for. We're no longer looking for, I don't know, let's see, there's medical liens if you don't pay your, if you went to the emergency room and you didn't pay your bill. The hospital can put a lien against your house. We don't necessarily look for those things anymore. We're just looking for primary tax liens, anything to do with the county.
I have a question, Melissa.
Yeah.
So what if you found something that a lien that against the property or the client, and the agent or yourself communicated with the client and they said that, no, this doesn't belong to me? What would happen?
Well, if that was the case, again, we'd have to reach out to whomever recorded that lien and get more information to identify that, yes, it was our client. No, it's not. We would probably put the client and the creditor together so that they can figure it out and dispute it. Unfortunately, if we can't confirm that it's not our principal party and our seller or buyer is, confirming that it's not them, we'd have to postpone closing. It would postpone closing until we had some kind of resolution from the creditor confirming that it didn't belong.
What if they sign an affidavit?
They can say that it's an affidavit. We do have a not me affidavit. Typically, we use the not me affidavit. Again, if there was a business tax lien, let's pick on poor VFAM again. VFAM had a nail salon, and our particular client with a name that was similar can sign an affidavit saying that they have never owned this kind of business at that particular address. But if you had a lien that had the same social security number or date of birth or driver's license as our client, it's an obvious hit. And then our client, even if they denied it, that they owed it, it would still have to be dealt with.
Got it.
So that would be the difference. And then that's about it that I have for our flyer. I have had a couple different incidents. I had a estate of life tenant that came over. So essentially, as you know, a parent, so I'm a mom of 2, and I'm going to give my house to my kids. I created an estate of life tenant, which means that, and I've added my children to title. When I do that, I basically have given the house to the children. But for as long as I live, I am allowed to stay in that house. And that was interesting to me because I hadn't seen one of those in quite some time. And so, you know, the life tenant had actually passed away at this point. So we did the affidavit of death, and then the house automatically reverted to the children on the title report. And it was pretty clean. That was kind of an interesting thing. You don't see that every day. And then, of course, you know, always our most sensitive transactions are the divorce transactions. You know, it's a personal decision to get divorced. Whatever the circumstances are surrounding it are personal and emotional. And the biggest problem we have, and I always tell my agents this up front, is have them decide right then and there how they're going to split their funds. I can't tell you how many times we've gotten down to closing and then they start bickering about the funds. They may have already agreed we're going to go to our joint account, and then they say, you know, at the last minute, no, I want, you know, my 50% here, and she says, no, you know, we agreed on this and I'm not going to agree to that. And again, I've had files delay in closing because ultimately we are only a facilitator of funds. We are not a bank. We can't hold funds forever, especially sellers' proceeds. I had a transaction where they, you know, on title, they were still husband and wife. They were in a trust. They agreed to send it to the trust. And then at the end, one of the spouses had said no, and I didn't hear back from them. So I just sent it all because that was the signed instructions I had. And the spouse that had said no, who never got back to me, was very, very angry. And he yelled at my listing agent and, of course, threatened future business and everything else. And, you know, I had to talk to my agent. I said, you know, I was very clear with this from the beginning. We cannot hold funds. And I know it gets emotional. And I know they fight in the middle of the transaction. And then they decide they want something different. But at the time of signing, they agreed to this. This is what I did. It's still a joint account, so they should still have access jointly to these funds. You know, I apologize that your client was upset with you, but again, you know, I can't sit on funds for 6 months until they go to court, and could be another year before. The worst case scenario for couples who get into that situation is I will forcefully suggest that if they have attorneys representing them, that I issue all of the proceeds to an attorney who is representing them, and they mutually agree, and I will send those funds for the attorney to hold, because an attorney is more willing to hold those funds for as long as necessary. You know, with the market shift, there's been talk about short sales, there's been talks about foreclosures, there's been talks about REOs. I haven't seen any, or the escrow officers in my branch haven't really seen any come through as of late. I've done a couple quotes where it's been a close short sale, but we didn't end up having to do the short sale. They were able to sell it for enough. If you do have questions about short sales or foreclosures, you know, please feel free to email me or call me. I'm happy to give you the knowledge that I have. I'm sure we may see them, in the upcoming years. I'm not quite sure, who knows. But that's probably about all I got for you guys today. Do you guys have any questions? Do you have any concerns? Anything that you've been seeing that you want to discuss or talk about?
Michael, is there any questions in the box?
Yes, there are. Can you see the questions?
No.
Well, Dee Dee asks, can you show us on the prelim where these red flags will be at, or do we need to read, this is in all uppercase, entire prelim?
So short answer, no. You do need to review your prelim because every prelim is different. If it's, if it's a condo or an HOA, it's going to have a longer legal description. There's going to be larger CC&Rs, more easements because it's a bigger project. It's a bigger area. If it's just a single family home, cookie cutter, it's going to be smaller. Essentially, our prelim, there's the original page 1 that's going to say you, because you are the client who requested the title report. It's going to have the property address. It's going to show who the owners are. You flip that page, that's going to be the legal description. After your legal description, there's going to be our exceptions, and it's going to be numbered 1 through, I don't know, it could be as short as 1 through 5 or as long as 1 through 13. Those are the items that you're going to want to look at. Okay. Those in that particular section is what's going to tell you. The first one's always going to be property taxes. It's always going to show you if they're due now or if they're due later or if they're paid current. Is there anything in default? It will say default. You'll have your CC&Rs. You'll have your easements. After that is what's going to show any current mortgages, any list pendants, any state tax liens. If we found them right away, it's going to show. So just remember, look at your prelim, check your owners, check your property address, flip through the legal description. The numbered items on the following pages are the ones you're going to want to look at.
Nermita asks if there are 2 separate trusts with the same successor trustee on the title, is that a concern?
No, a lot of people have different trusts. I actually had a client who had their own personal trust, and then they had a survivor trust. They actually had a special needs child. So they had 2 separate trusts set up for them and then for their special needs child. They're 2 different kinds of trusts, but they were basically the same.
What can a homeowner do when they want to sell the home, but they have a co-signer on the loan and title, but the co-signer doesn't want to incur the tax consequences on the sale because they never lived there?
There's not anything that they can do. I've had situations where there's multiple people on title and that own the property, and say, let's just say Mike, Lynn, and I own a house. Mike's never owned it. He co-signed it, and Lynn and I, made all the payments, paid all the property taxes. Lynn and I are going to collect 100% of those proceeds, and Mike is going to get 0%. So again, you can refer to your CPA and talk to them and see what the different options are for them. But, again, there are options.
So see, the words that jumped out at me was not only are they on the loan, but they're also on title. So if you have co-tenants and one co-tenant doesn't want to sell, I think we're talking about a lawyer and a petition action.
Yeah, and you could actually go for a quiet title action if that was the case, yeah.
Right. So and this, by the way, happens. I have some right now going on where, 2 people bought the property together, tenants in common, why not? One wants to sell it. The other one is like, well, I have no place to go. I'm just going to stay here. I don't want to sell it. So now they both have lawyers, and the court action, the petition action forces the sale of the property. But this is not the cheapest thing.
No.
Not the cheapest.
I have a quiet title action. I'm not even sure exactly what happened. A brother bought the home for the intent of the sister. The sister was married. For whatever reason, they put it in her sister's husband's name. Her sister's husband never made any payments, never paid the property taxes. And the sister now wants to sell her home, and the husband, who's now the ex-husband, of course, says, no, you can't. I'm not going to let you. She had to go to an attorney. They had to do a quiet title action where the judge actually awarded the home to her so that she had the ability to sell the property.
Yeah. Yes, you need to talk to a lawyer and a CPA. And a lot of times when they're doing this, they look at payments of property taxes, who's been paying loans as a way of determining the split, but it's still, a pain. For Ellen asks, for a seller in possession for a month after close of escrow, can we leave the sum amount in case there might be damages left? Security deposit left in escrow after.
That's different, yeah. We do that quite often, but again, it has to be for a specified amount of time. And our instructions say, I type them up as so that I'm going to hold it for 30 days. If there's no resolution after 45 days, I will release the funds back to the seller.
Yeah, they just don't belong to, don't they just belong to Chicago Title at that point?
I wish. I thought it was my tip, but apparently I was wrong.
Bonus time. What can a sole survivor need to sell an empty lot she owned with her husband who already passed away? What do you need to, I think the question is, do you need a death certificate? If you're talking about sole survivor, I assume they're talking about joint tenancy.
Yeah, depending again how they're holding title, whether it's a trust or husband and wife, we would record and file an affidavit of death of joint tenant, affidavit of death of trustee. If they are in a trust and you have one of the trustees pass away, just make a note. We always need to have a full copy of the trust. Title wants to verify the intent of the trustees to make sure who the beneficiaries are.
Is the property tax assessed on the purchase price or assessed value by the county?
Purchase price.
Right. And then over time, it's the assessed value maximum increase of 2% a year.
Correct.
Soledad wants to know if you know any real estate attorneys in San Jose.
We do actually. Lynn says
you can email me.
Email them. I know some too, but, and then Ellen says, thanks. They had no, Soledad is, which question is this? This is, I guess, the joint tenancy. They had no trust or will. They owned the lot as husband and wife. That would assume community property then, I guess.
It would, and then unfortunately, because community property does not, that's sticky, you want to double check that because it could be subject to probate at that point.
Right. Now, it is possible to have community property with the right of survivorship.
Yes.
This, you need to know the conveyance kind of a question. Because it could be, you never know, I don't see a lot of those, maybe you do.
I hope for their sake, it is community property with right of survivorship.
Right. Yeah, if it says in the deed husband and wife, as husband and wife, it's presumed community property in California. I don't know if we have any more questions. We seem to have exhausted, we've worn them out.
Well, again, if you think of anything, Lynn and I are always here. We're happy to answer questions, emails. We'll be, make ourselves available as much as we can.
I just wanted to mention one of the weirdest ones that I had. was somebody that was on my team who's very meticulous, gets the prelim, reads the prelim. There's nothing special about it. The prelim included a hyperlink to the deed, which this agent did not click on and read the deed. And I have to admit, I typically, as an agent, don't click on the link and look at the deed. I don't, but apparently nobody else did either. And the issue, and the reason I'm mentioning this is because this is coming up more often. Let's say the person bought the property through one of the down payment assistance programs, which is what this was, either the Silicon Valley Housing Trust or the Santa Clara County Housing Trust. And it says that on the deed. Well, the issue is that if the person who's selling it bought it through down payment assistance programs, they're oftentimes limited as to their ability to sell it to somebody else. So in escrow, finally, somebody looked at the deed where it said, this was not Chicago Title, by the way, where it said that this is part of the, I forget which one of the two housing trusts, and there was actually a covenant as to what they could do with it in the future, which basically means they couldn't sell it. And, the buyer is doing notices to perform. You can't sell it. You can't sell it, right? Because of that. And that agent asked me if I usually looked at the deeds, and I'm starting to, but those are questions. If you're listing the property, you might want to, if you hear that they bought it through some special means, that would be something to talk to your escrow officer about at the beginning. Right.
Well, also the listing agent responsibility is communicate that with the seller and put that on MLS if it's below market rate property, right? Because I've seen
this was
that.
about 20 years ago, and apparently the seller didn't mention it to the listing agent, so the listing agent didn't mention it. Seller figured it was over 20 years ago.
Yeah, they may not have remembered at the time, especially if it's been that long, that, yeah.
But it was on the deed.
Well, maybe then is a good idea to ask every time you list a property, is this a BMR?
Yeah. Tell me about how you bought it. Anyhow, yeah, it was all right. So I don't see any more questions. We've given them several chances. So I guess we're going to let them go.
All right. Well, thank you, everybody.
Thank you so much. And please feel free to reach out to us if you wanted to sit down one-on-one to review your business plan, your farming strategies. Please reach out to me.
I've put your information twice in the chat. Plus, it's on the handout, which I have a copy of. And if you still can't find Lynn's contact information after all that, send me an email. All right.
Okay, sounds good. Thanks, Mike. Thanks,
Mike.
everyone.
Bye.
Have a great afternoon.